Unlike the federal legislative framework, Western Australia's anti-discrimination laws are consolidated in one Act, being the Equal Opportunity Act 1984. The grounds of discrimination protected by the Act are sex, marital status, pregnancy or breastfeeding, gender history, family responsibility or family status, sexual orientation, race, religious or political conviction, impairment, age, and fine status. It must also be linked to one of the areas of public life specified in the Act, including work, accommodation, education, provision of goods, services and facilities, access to places and vehicles, disposal of land or estate, clubs, application forms, advertising, superannuation schemes and provident funds, insurance and sport. The Equal Opportunity Commission also has jurisdiction over complaints of unlawful discrimination brought under the Spent Convictions Act and the Public Interest Disclosure Act. It's important to note that not all areas of public life are covered by every ground of discrimination. It may be useful for you to refer to this table created by the Equal Opportunity Commission, which summarises the grounds and areas of unlawful discrimination in Western Australia. Let's take a quick look at the structure of the Equal Opportunity Act. One of the first things you might notice is that the key parts and divisions relating to discrimination are all structured very similarly. Division 1 of each part will generally set out what constitutes discrimination on the certain grounds covered by that part. Division 2 then sets out when discrimination on that particular ground will be unlawful in a work context. Division 3 will generally set out unlawful discrimination in other areas. There may be additional divisions relating to unlawful harassment or specific exceptions. The Equal Opportunity Act also makes other acts unlawful, specifically victimisation and the publication or display of an advertisement that shows an intention to discriminate. Part 6 sets out general exceptions to the Act. The Act also establishes the role and functions of the Commissioner for Equal Opportunity and details the procedures and functions of the State Administrative Tribunal in handling complaints under the Act. The Act also covers equal opportunity in public employment as well as miscellaneous provisions such as offences and vicarious liability. Let's now take a look at some of the general issues that might arise when interpreting and applying the Equal Opportunity Act. The Act does not define discrimination, but describes types of conduct which constitutes direct and indirect discrimination. Direct discrimination occurs when a person has a protected attribute and the discriminator treats the aggrieved person less favourably than the discriminator treats or would treat another person in the same or similar circumstances. The test for direct discrimination under the Equal Opportunity Act is comparative, involving comparing the treatment of the aggrieved person with the real or hypothetical treatment of another person who does not have the same attribute. In contrast, anti-discrimination legislation in other jurisdictions contain an unfavourable treatment test, where discrimination can be established if an alleged discriminator treats or proposes to treat another person unfavourably because that other person has one or more protected attributes. The WA Act is likely to be amended to reflect the more modern unfavourable treatment test, but in the meantime note that you will ideally be able to provide evidence regarding a comparator. Indirect discrimination occurs when the discriminator requires a person with a protected attribute to comply with a requirement or condition with which a substantially higher proportion of persons without the same attribute as the aggrieved person comply or are able to comply, and which is not reasonable having regard to the circumstances of the case, and with which the aggrieved person does not or is not able to comply. An early and simple example of indirect discrimination is the minimum height restriction that was historically imposed on police recruits, which resulted in discrimination against women and people who were genetically predisposed to be shorter than average due to their ethnicities. Discrimination can be based on the ground itself, so for example, the actual sex of the aggrieved person, or it can be based on a characteristic that appertains generally or is generally imputed to persons with that certain attribute. In some instances, discrimination can also occur where a relative or associate of the aggrieved person has that particular attribute and the aggrieved person is treated unfavourably as a result. In addition to covering unlawful discrimination on the grounds of sex, marital status, pregnancy, and breastfeeding, Part 2 of the Act makes sexual harassment unlawful in the context of employment, education, and accommodation. In order to establish that a person has been harassed sexually in breach of the Act, the conduct must constitute an unwelcome sexual advance, an unwelcome request for sexual favours, or other unwelcome conduct of a sexual nature. A disadvantage test must also be satisfied, where the aggrieved person must either have reasonable grounds for believing that a rejection of the advance, a refusal of the request, or an objection to the conduct would disadvantage them, or that their actual refusal has disadvantaged them in connection with their employment, studies, accommodation, or application for those things. A similar test arises in the context of racial harassment. The Equal Opportunity Act protects a gender reassigned person from discrimination on the grounds of their gender history. The protections under this part of the Act will only be enlivened if the complainant has been issued with a recognition certificate under the Gender Reassignment Act or equivalent. This requires that they have undergone a reassignment procedure, which is defined in Section 3 of the Gender Reassignment Act. The Act in its current form is very limited and means that people who cannot or choose not to obtain medical or surgical treatment to affirm their gender are currently not protected. The provisions protecting individuals from unlawful discrimination on the grounds of sexual orientation are contained in Part 2B of the Act. Sexual orientation under the Act encompasses heterosexuality, homosexuality, lesbianism, or bisexuality. Other jurisdictions, such as Tasmania and the ACT, have adopted a non-exhaustive definition of sexual orientation or sexuality to allow for greater inclusivity. Under Victorian legislation, sexual orientation is defined as a person's emotional, affectional, and sexual attraction to, or intimate or sexual relations with, persons of a different gender or the same gender or more than one gender. General exceptions are contained in Part 6 of the Act, which relate to acts done under statutory authority, charities, voluntary bodies, religious bodies, educational institutions established for religious purposes, and establishments providing housing accommodation for aged persons. There are also exceptions that are specific to certain parts and provisions of the Act, and it is important to check each provision carefully. Practical tools and tips. An additional resource that may be beneficial to you and your clients are the fact sheets prepared by the Equal Opportunity Commission, which can be located on their website. These provide detailed summaries of each individual ground of discrimination covered by the Equal Opportunity Act, including what constitutes direct or indirect discrimination on that ground, the areas of public life that the protection applies to, exceptions, examples, and the obligations on people and organisations to ensure compliance with the provisions of the Act. There are also fact sheets setting out what constitutes unlawful discrimination more broadly, other unlawful acts such as victimisation and advertisements, and the complaint processes under the Act. You should also consider the various limitations of the Equal Opportunity Act, including the low compensation amount awarded under the Act, the limited recognition of intersectional discrimination, the need for a comparator, the limited areas protected from racial and sexual harassment, and limited protection in schools and for trans people. A large number of the discrimination matters referred to the State Administrative Tribunal do not succeed, and so it is important to gather as much evidence as possible from as many witnesses and as early as possible. Although this is primarily a self-represented jurisdiction, the complexity around this area of law means it is critical that you treat this like any other matter. It is important to note that complaints to the Equal Opportunity Commission must be lodged within 12 months of when the incident took place, and it is often difficult to have this timeframe extended. You may need to consider whether the state or federal jurisdiction is best suited to your matter, which we discuss in more depth in video 4. Another issue you may need to consider when advising your clients is in relation to non-disclosure agreements. It is extremely likely that they will be asked to sign one, but it is important to inform them that they are not required to do so.